Okay, let's go on the record in cause number 2020 CR 0499, the state of Texas versus Jimmy Turner. Attorneys, please make your announcements.
Ryan Grimmer for the state of Texas.
James Ishimoto for the defense.
We're here for a pretrial hearing on some motions that the defense has filed. Mr. Turner is appearing by video conference from the Bexar County Jail, and this is on the charge of murder, correct? Yes, on the charge of murder?
Yes, Judge.
Okay, so what I'm going to do is I'm going to go ahead and read out the motions that you all have already agreed on, and then we're going to move on to the ones that are disputed. The first motion that I have is the defendant's request for a pretrial hearing. So as to the motion in limine and as to the motion to suppress, everything else is granted. Those two we will run with trial. The request for a pretrial hearing is granted. The motion to require an official court reporter to make a full record, that one is agreed as well.
Yes, Judge.
Okay, granted as pled. The defendant's motion to reveal agreements entered into between the state and its witnesses, that is also agreed.
Yes, Judge.
Is there any agreements that you have made with any witnesses, state?
They're not, Judge, and if that changes, we will let the defense know at that time.
That's granted, as you guys have both agreed. Brady motion for discovery of all favorable and exculpatory evidence, state, that's agreed?
Agreed, Judge.
I will grant that motion. Motion for witness list, state?
Agreed, Judge.
For purposes of the record, I do have the state's list of witnesses and designation of experts that was filed yesterday. Mr. Ishimoto, did you have a chance to review that list?
I believe I received it, Judge. I haven't reviewed it, but I'll take a look at it.
All right.
If there's any issues, I'll bring it up with Ryan. It's a rumor.
The defense's motion for a witness list is granted. I do find that it has been complied with, and if that list is state, please supplement it to Mr. Ishimoto.
Of course, Judge.
For purposes of the record, I also have a request from the defense for notice of intent to offer extraneous conduct under 404B. I also find that the state has supplied that. They've already filed a written notice of intent to offer extraneous offenses at trial. So state, if I'm going to grant, there's nothing to grant, but if that is an ongoing obligation, if there is anything you're going to add on to that, please supplement it timely to Mr. Ishimoto.
Will do, Judge.
The motion to suppress and the motion in limine will run with trial. And so what I have left is motion for discovery, production, and Rule 702 hearing. Have you guys gone over that motion?
Judge, I believe those last two motions are the ones that we just have to briefly take up with the court.
Okay, I'm sorry. So the motion, this is not a motion. This is the defendant's notice to require discovery under 3914. Obviously, that is just a notice to the state, nothing to rule on there. Mr. Ishimoto, has the state complied with that request?
Judge, there are numerous issues that they're working on. I understand there's a lab report that they're going to forward to me. There's a standard discovery packet from the crime lab that I think is coming to me. They're tracking down some EMS records that they're going to send to me. There's some university records of the defendant's injuries that they're going to track down and get to me as well. There's some reports as to the complainant and the deceased and the witness in terms of cases they have pending that they're also going to forward to me. So there's a bunch of things that they're in the process of complying with.
Okay.
Jail calls too, that are supposed to come to me.
Okay, so we're still gathering everything then, right, state?
Judge, to be honest, a lot of that is small odds and ends. It's other than the medical records from university, which I only became aware of a couple weeks ago when Mr. Ishimoto talked to me about. The rest of the stuff I think should come pretty quickly. Hopefully the medical records will too. But but most of the stuff is stuff that is not real hard for me to locate. It's just stuff that James wanted that I'm looking into.
Okay, so what is the part that is unagreed that requires a ruling?
Okay, so Judge, if we can go to the motion for discovery and inspection, that's the longer one of the two that we're going through.
Yes, I have it.
Okay, and we are agreed on numbers 1 through 11.
Give me a minute. I'm going to pull up the motion on the screen so we can all look at it together.
Okay.
This is the motion that is entitled Motion for Discovery and Inspection, correct?
That's correct, Judge.
Yes, Judge.
My logon is not working, so give me a minute. Okay, the motion that we're going over should be popping up on the screen. Okay. So 1 through 11 is agreed?
Correct, Judge.
Okay, what's next?
Okay, on 12 and 13 both may cover this issue, and I think Mr. Ishimoto wants to speak to it. Just to give the court some knowledge about what we're talking about. After this, in the investigation of this murder, it happens in front of the alleged murder happens in front of a motel room. In their investigation of the search scene, they find some apparent narcotics. They find a couple of different bottles of pills. They also find some marijuana and some apparent crack cocaine. Mr. Ishimoto, I think, wanted to bring up that he was perhaps going to try to ask the court to have us test those items. The state's response is really, we're not fighting that they are what they are. We will stipulate that these things are the narcotics that they're alleged to be to save the court and the law enforcement the time of having to test that. We're not arguing that these things aren't narcotics. Now, we do reserve the ability to argue as to their admissibility, but the state has no objection to stipulating that the apparent crack cocaine, the pills, and the marijuana are what they are. But I think Mr. Ishimoto wanted to speak to the court regarding that issue.
Go ahead, Mr. Ishimoto.
Judge, yeah, in the complainant's motel room, there's items that were collected that are just marked, like 2 yellow pills, 2 white pills, 16 multicolored pills. So there's a bunch of things that they've collected that they have not identified. I think from watching the girlfriend's statement that it just seems that there's a probability that she may have been using some of those drugs. And in an effort to properly cross-examine her, I kind of need to know what those drugs are. And also, I think another issue is in terms of what is a reasonable use of force by the defendant. I think the fact that the defendant is a drug dealer is going to be an issue. And in terms of knowing what drugs were in that particular motel room, I think it's important that they be tested. And so it just seems like the quickest and easiest way to do it, just send it to the Bexar County Crime Lab where they can test it and for rather cheaply as opposed to some other more expensive route.
Okay, as to items 12 and 13, that is granted. State, please have those apparent narcotics tested and identified so that Mr. Ishimoto can properly cross-examine the witnesses and properly prepare for his defense.
Okay, Judge. Judge, from from numbers 14 through 19, we agree through 14 through 19 are agreed. On number 20, Judge, there's only a small amendment that I believe we've agreed to. 20 ask any and all names, addresses, and phone numbers. It's basically asking for stuff about the expert witnesses. On the back end of it, it says, and the studies or name of studies that they've relied on upon to render their opinion. I think I talked to Mr. Ishimoto, and he doesn't need that part. We just need the names, addresses, and their CV. So we would just strike the language of the studies and names of studies they've relied upon to render their opinion.
That's correct, Judge.
Okay, so request number 20 is granted as modified. We will strike the language that deals with the studies or names of studies they have relied upon to render their opinion. What is the next item?
We agree to 21, Judge. 22, we partially agree. I don't think we're arguing about anything. I think we just need to alter the language a little bit. 22 is asking for TCI NCICs regarding certain individuals involved in the case. We have agreed that we're not able to provide them a copy of the TCI NCIC, but we will let them examine any TCI NCIC or create a summary of the information therein. For all the lay witnesses in the case, Judge. It does say all witnesses. Generally, I think that the court, we don't run TCI NCICs on all officers just because, just the nature of their profession, but we will run it on all lay witnesses and the defendant and the victim.
Mr. Ishimoto?
Judge, I don't need a copy of it. I mean, obviously, if it's in the court, if it's in the state's file, I can make an appointment to look at it in the state's file. So I don't need a copy, but I would like them to run a recent copy of the NCIC prior to trial.
Okay, so the request 22 as to A, the defendant is granted, B, each witness the state intends to call, that is granted as to lay witnesses. And every person identified in discovery is the same ruling as 22B. However, Mr. Ishimoto, if you have information that an expert or a police officer or anyone else needs to have their criminal history run, certainly you can file a separate motion addressing what the issue is, and we can rule on that in that way.
Yes, Your Honor.
Okay, which one is the next one?
Judge, we agree to 23 and 24. On number 25, Judge, we agreed to all of it except for we both have agreed to strike the last part where it says occupation, physical descriptions, and photographs or mugshots.
So as to this request, Mr. Ishimoto, was there more than one person who was interrogated, questioned, contacted, or arrested in conjunction with this offense?
I think there were some, there's a girlfriend, there's her sister, there's some people who were talked to. And so I think that's just a general request to see who they talked to so that we're aware of it.
Okay, was this an arrest that was made contemporaneous with the findings? Like they found there was a murder, there was a dead body, and the
Correct.
arrest was contemporaneous?
Yes, Judge. It was all in. It was kind of contained. It doesn't appear. There was an incident that led to an arrest immediately. The arrest occurred pretty concurrently with everything that was happening.
Okay, I understand. And so you both agree that as to number 25, request 25, you're going to strike occupation, physical descriptions, and photographs or mugshots? Mr. Ishimoto, you're agreeing to striking that?
Yes, Judge.
All right, so number 25 is granted. We will strike the wording where it reads occupation, physical descriptions, and photographs or mugshots. What is the next one?
Judge, we agree to 26, 27, and 28.
Thank you. What is the next one?
Judge, on 29, I guess this is one, and I think we have an agreement as to what the plan is. I understand why Mr. Ishimoto is asking for this. 29 states any medical evidence of the complainant or other states witnesses who have been diagnosed with a mental or psychological conditions which may influence their ability to recall facts or may impair their ability to correctly recall the facts. I've told Mr. Ishimoto that I am going to inquire as to any of the lay witnesses, whether any of these issues are present. If I know anything, either based on prior contact with law enforcement on some other case and or something from them or one of their family members, I will inquire at that time. But some of this, if I don't know about it, obviously I don't know about it, but I will make reasonable efforts to figure out if any of these things are present.
Mr. Ishimoto, do you have specific information that would assist the state in getting that to you?
Judge, our concern for number 29 was in the past. There's been a situation where mental health issues have come up that arguably the state may or may not have been aware of. And so our position is if the state is aware of it, certainly they should tell us. And I think that is the agreement.
Okay. Number 29 is, so it's granted as it is written, Mr. Groomer, or are you guys changing the language? Granted, okay, I get it. So number 29 is granted if you become aware of it, state.
Right. Yes, Judge, I think that's the best summary.
Okay, next.
So 30 through 33 are agreed, Judge.
Okay.
And 34 is one that we've agreed, I guess, to modify it a little bit just because James has asked for, and I guess this is kind of what it's asking for, but he's asked for some police reports regarding another offense that Michelle Aguilar, who's a witness in this case, has been arrested. Basically, the police reports and any lab reports related to that offense, as well as the pending criminal cases that the complainant had at that time. And the state has agreed to give those to the defense as to any pending criminal cases the defendant had at that time, and Michelle Aguilar's criminal case that has happened in the interim since then.
And Mr. Aguilar is a witness?
Miss Aguilar, she is a witness, yes.
Okay. So why does it say defendant and complainant? Why are we, is there a separate, is the complainant have a different name? What is the complainant's name?
The complainant's name is Kevin Ryan.
We're on number 34, correct?
Correct. So I guess this is just referring to the complainant. At least in Mr. Ryan's case, then we will provide the documents related to his pending criminal cases at the time of his death.
Okay. Is that what you're looking for, Mr. Ishimoto?
Yes, Your Honor.
Okay, so number 34 is granted. The state will supply any arrests that were pending at the time of death. Is that correct?
Correct, Judge.
Okay. Okay, what's next?
So that's 35 we agreed to, Judge, and I think that's it on that motion.
Okay, so 35 is agreed.
Correct.
What I will do is I will go as rule on the motion itself. So you have granted, denied. I will rule on the motion itself and then sign off on all the motions and get those to you. All right, what else do we have, gentlemen?
Okay, Judge, just the last motion is the one that's titled Motion for Discovery Production and Rule 702 Hearing.
Okay.
And Judge, I think we've agreed on this one. The language of the motion asks for some stuff that that I don't think Mr. Ishimoto is looking for, and I just want to make sure we're on the same page on it. If you go down to subset, I guess number 9,
Okay.
is some of the things that it's asking for. And it's asking for, a statement of the expert's opinion and literature relied, and some of the stuff that I think we will get into at that 702 hearing. So I think that Mr. Ishimoto is not looking for that stuff. I think that we've agreed to provide to him the name, address, and the CV of any expert witness that we're designating for trial, which is under subsection B. And then I think the rest of it is stuff that he will go into at that hearing, which he's able to go into the Daubert hearing, but is not stuff that we are going to, basically that stuff will come in at that point where rather than what it's asking for in the rest of number 9 there.
Okay, Mr. Ishimoto, can you tell me what you're looking for? Because subsection A is asking for a concise and specific statement of each expert opinion the state intends to introduce at trial. So are you saying that in addition to any reports that already come with the normal discovery, that there may be some other stuff that you're entitled to?
Judge, I believe the concise opinion should be the report. I just wanted to cover my base, and if there's anything in addition to that that they may have written on or something, I would certainly want that. The state has agreed to give me sort of, I guess, the enhanced discovery packet that the crime lab does. So for that usually include notes and stuff, but I just wanted to make sure that if there was anything in addition to that, that they provide that.
Okay. Is there any item of discovery that addresses subsection C? That talks about underlying theories, methodologies, or techniques used or relied upon by each state witness. Is there anything in addition to the discovery that you're already going to receive that you're looking for? Anything specific?
Not at this time, Judge.
Okay. Why don't we do this? Since you both have agreed to B, I will grant the request for 9B, and I will just not rule on the remainder of the request. If something comes up, then we need to be able to bring it back up and rule on it. Does that make sense?
Yes, Judge.
And
That's fine.
this 702 hearing, we're going to run it with trial, correct?
Yes.
Okay.
Yes, Judge.
So I will be very clear in my order that I'm only ruling on subsection 9B. And if there's any other issues that come up with the 702 hearing, please alert the court so we can have a hearing on those. All right, those are all the motions I have. Is there anything else before we get off the record?
No, Judge.
Just to bring to the court's attention, I will be dropping by an ex parte motion next week, but just that would be separate, Judge.
Okay, all right, no problem. We usually take care of those on a sealed basis, and then we make them part of the record under a sealed basis. Mr. Turner, do you have any questions, sir?
Yeah.
All right. Thank you all. We're going to go off the record.
Judge, could you put me in a breakout room or something with the defendant briefly? I would
Yes.
appreciate that. Thank
Absolutely.
you.
I will not end the meeting. Let me see. Mr. Turner, if you can ask one of the COs to help you get into a breakout room, it's breakout room 1. And there you go. Thank you. You're excused.
Thank you, Judge.
Okay, take care.